Sam McLure. I am the founder of the adoption law firm, and today I want to talk to those foster parents who've had a child in their home for a significant amount of time and the parents haven't rehabilitated. In those situations, of course, we're looking towards termination of parental rights and adoption to provide permanency for a child. If you're in that situation, then there's a phrase that is very important for you to understand, and it's got a broad pathway on which it runs, and that phrase is no viable alternatives. Today in Alabama, that phrase, no viable alternatives, is actually one of the prongs that the trial court must hear clear and convincing evidence about in order to grant an adoption. Those prongs are: there must be evidence of dependency. That means the parents are unable and unwilling to parent the child. There must be evidence that one or more of the grounds for termination of parental rights have been met. There must be no viable alternatives to termination of parental rights, and it must be in the child's best interest. So that phrase itself is a little bit of word soup, so let me unpack it. So a viable means living, it means active, it means usable. Alternative to termination of parental rights would be something like, hey, there's a grandparent that is ready and willing to take custody of the child, or there's an aunt or an uncle ready and willing to take custody of the child. There has been an additional prong added by the appellate courts in which a foster parent's amenable attitude or disposition towards a legal parent can be a viable alternative to termination of parental rights. We'll circle back and talk about that at the end. But first of all, the department from the very beginning of the case has a duty to go search for and look for relatives. So one of the first things that the department should be doing with a legal natural parent when the child comes into care is sitting down with them and having them fill out a relative resource form. This is a form where the legal mother or the legal father writes down all the potential relatives who could care for the child. Right? In some counties, the juvenile court will actually ask the parent from the bench what relatives are there who could care for the child. Whatever that method, the department has a duty to then go take those names that are given to them and notify those parents, to send them certified mail, to keep a record of the certified mail, send them letters, and if those relatives, whoever they are, and when they're contacted, they've got to be contacted in a timely way. If those relatives don't come forward within the first 4 months of receiving notice and assert their desire to gain custody or care for the child, then the court doesn't have to give them preference as a relative in any placement consideration. So that piece, I think, is really important for foster parents to understand, because caseworkers are busy. Caseworkers have to spread their mama bear mojo over lots of kids, and as you care for just one child or multiple children, you can really, in a gracious way, come alongside a caseworker and say, hey, how are we doing on those relative resource forms? Hey, anything I can do to help you? You're doing a great job. Have we sent letters to all those relatives? And so really important as the foster parent, the chief advocate for the child, that you can help and come alongside the department. The other thing that I think is important to consider and understand is the department usually uses a search tool called an accurate search. So the court may elicit names, the parents may put names on the relative resource. The department should also be using accurate searches to see, are there any matches to potential relatives out there. And again, the department needs to be sending out letters, certified letters. This is the child, they're in care, if you want to step forward and care for the child. So that's another thing that you can graciously come alongside the department and bring up in discussion in a real kind and friendly way. Now, there has been some very troubling case law that's come out in the last few years that if a foster parent is on the stand during the course of a termination of parental rights trial and testifies to things like, I think that I really like the natural parent, we have a good relationship, I am open to an ongoing visitation, the court will consider that as a viable alternative, just maintaining the child in foster care. Because if the foster parent's amenable relationship with the natural parent is a viable alternative to termination of parental rights. Now, we think that's bad case law. We think that's case law that should be overturned, and it's bad for kids. What we want out of every foster parent is for the first 12 months of that child's life to be leaning into good relationship with the natural parents, to helping them reunify, to text them updates and pictures, and if it's feasible and healthy, inviting them to the child's birthday party, et cetera, et cetera. And so I think what the courts have done here is turn that healthy relationship against the child and preventing the child from having permanency. So that's something to consider if you're approaching the termination of parental rights. If you have any questions about this or the implications of anything having to do with this no viable alternative prong, please don't hesitate to reach out to us today.